If you're trying to figure out how to get a house into your name when its owner dies in Missouri, you're in the right place. Today, we're going to break down all of your options from simple transfers to full probate cases. Hi, my name is Dan Schnurbush. I'm an estate and probate attorney out of St. Charles, Missouri. We help clients all across the state of Missouri deal with probate and trust administration when somebody dies. So the first thing to understand when somebody passes away owning a home is that home even probate property at all? First of all, what is probate? Probate is the in-court process of transferring assets from the name of a deceased person into the name of the heirs, okay? So when is that required? If a house has a joint owner, a joint tenancy with right of survivorship, or a spouse, in Missouri, this can be in the form of a tenancy by the entirety, which is the same thing as a joint tenancy with right of survivorship, except it's only between married couples, and also offers a little bit of asset protection for the debts of any one spouse. So if there's a joint owner, when one of the joint owners dies, the property automatically transfers to the other joint owners. Same in a tenancy by the entirety. So if two spouses own a property together, it'll automatically transfer to the other owner. That's not probate property. If you want to take the person's name off the title, you can, but you don't really need to unless or until you decide to sell or refinance. And in most cases, the title company will do it for you. The other situation where a title will transfer automatically without probate is if there's a beneficiary deed on the property. To figure this out, you need to check with your recorder of deeds office and see if any beneficiary deeds have been recorded for that piece of property. This is going to be the recorder of deeds office for the county where the piece of real estate sits, okay? It's helpful to check the deed for the joint tenancy issue as well. And you'll look for the warranty deed or the quitclaim deed by which the owner actually obtained the property, and you can see how it's worded. It'll usually say something, if it's joint, it'll say something like Jim and Alan Smith as joint tenants with right of survivorship. If it doesn't have that magic language, it'll be a tenancy in common, and then it'll need to go through probate. The other way that property doesn't need to go through probate is if it's held in a trust. If it's held in a living trust, it will pass according to the trust terms rather than according to probate or any other system. So let's assume you have a property, it doesn't have a joint owner, it doesn't have a beneficiary deed, it's not in a trust. In this situation, it's going to need to go through probate. So how do we do that? What kind of probate methods are available for a property in this kind of situation? The default answer is a full probate administration. This is the typical situation where you have an estate that is net value exceeds $40,000. So if you have a house worth $200,000 and it has a $100,000 mortgage on it, that's $100,000 in equity. So the net value of the estate is $100,000. If it is over $40,000 and within 1 year of death, a full probate administration is typically what would be required to administer and transfer the title of that property into the name of the heirs. If the net value of the property is lower than $40,000, including any other probate assets, you may qualify for a small estate affidavit. This is a much more efficient process. Generally lasts, instead of a year, it's going to last more like anywhere from 5 to 8 weeks, typically, depending on your county, depending on if there's any complications, but it must be filed by an heir. Another method, and another short form probate method, is called a determination of heirship. This is only available in Missouri when it's been longer than 1 year since death, and it's typically used when the total assets are over $40,000. If it was under 40, you'd just file a small estate in most cases, all right? So a determination of heirship is very similar in length to a small estate, typically more like 8 to 10 weeks. There's going to be a petition that gets filed. There's going to be a court hearing set, publication in the newspaper. It takes a little bit longer and it does involve a court appearance, but it is much faster than a traditional full probate administration. And one more short form probate is a refusal of letters application. Two different kinds, one for minors and spouses of the deceased. This can typically be filed if the net estate value is less than $20,000 if you're in St. Louis City, $24,000 if you're in St. Louis County. If it's a different county, you're going to have to call the probate division and figure out what their limits are for these kinds of refusal letter applications. The last kind of refusal letter application is for a creditor refusal. Very rare it would work on a house, but it can work if the net estate value is less than $15,000 and you have a funeral bill that exceeds or close to exceeds that amount. This could work in certain situations. And then there's one special situation you should be aware of. If it has been longer than a year since death, and the only asset of the estate is real estate, in some cases, you can get away with filing just a simple affidavit of heirship. This does not require a court appearance. It does not require a court filing at all. It's actually just an affidavit that gets recorded in the county recorder of deeds office, and that in many cases can be sufficient evidence in the chain of title to satisfy title companies if you want to sell it or refinance it. You can usually satisfy a lot of third parties with a simple affidavit of heirship after a year of death when the only asset is real estate. So what are the key takeaways? First, we need to figure out if it is probate property at all. Look for joint tenancy, look for tenancy by the entirety with a spouse, look for beneficiary deed. If so, probably doesn't need probate. If those things are all missing, it may be necessary to go to probate. And whether or not that's going to be a big pain is going to depend on the size of the net estate value and how long it's been since death. Thanks guys for listening. If you liked this video, if you enjoyed the content, subscribe and check us out in some of our other videos. If you need help in your particular situation, don't hesitate to reach out. Again, my name is Dan Schnurbush, and we represent clients across the state of Missouri in probate and trust administration situations. Until next time, guys, thanks.